We should go live in a few moments. As soon as I get the green signal, I'll start speaking. I'll do the introductions, and then Professor de Guzman, the floor will be yours. Greetings to everyone present. My name is Ankit Malhotra. I'm the co-founder and president of the Jindal Society of International Law. The Jindal Society of International Law is a student-led initiative formed under the aegis of the Center for the Study of United Nations, which is expertly and quite adroitly headed by Professor Dr. Weston Bobowski. We were officially founded on the 18th day of November in 2020 by the Herbert and Rose Rubin Professor of International Law, Professor Jose Enrique Alvarez of New York University, along with our university's respected Vice Chancellor, Professor Dr. Siraj Kumar. Professor Dr. Weston Bobowski, who's the faculty coordinator for the society and also the executive director for the Center for the Study of United Nations. We were also joined by a dear friend of the society, Professor Dr. Mohan Kumar. The purpose of this society is to increase the student interaction with the subject matter of international law, and through its series entitled Colloquium on Challenges to Global Governance and the Humanities in the 21st Century, this offers a compendium of scholarship from the academy and professional experience from the bar. Over the past years, the Society has hosted over 100 speakers from foreign universities, members of the International Law Commission, international law firms, the United Nations, the Institut de Droit International, the World Bank, and the Hague Academy of International Law. Through our previous series, we endeavored to study the different contours of international law through our speakers who cover and address the respective areas of expertise based upon the years of research and practice. Given the vast ecosystem of international law and the engagement in it, the society aimed to study the fragmentation and fertilization of these various disciplines in international law. Through our series, we hope one will develop a deeper understanding of Philip Jessup's magnum opus, A Modern Law of Nations, an introduction which he wrote in 1949 when he said, and I quote, "So long as the international community is composed of states, it is only through an exercise of their will as expressed through treaty or agreement or as laid down by an international authority deriving its power from states that a rule becomes binding." And to speak about such rules and also the future of tribunals created from such rules, we will now discuss the future of international criminal tribunals. And to assist in the study, we're quite honored and we're also quite delighted to be in the company of Judge Professor Margaret de Guzman, who is the James E. Beasley Professor of Law and the co-director of the Institute of International Law and Public Policy at Temple Law School and a judge of the Residual Mechanism for International Criminal Tribunals. She specializes in criminal law, international humanitarian law, international human rights law, and transnational justice. She also teaches a course on mindful lawyering. Her scholarship examines the role of international criminal law in the global order with a particular focus on the work of the International Criminal Court. She's also written extensively on these topics and has been deeply inspiring in her work and is an instrumental figure in transforming thoughts on these matters. We're also joined by Professor Milenia Stereo, who earned her law degree as a magna cum laude from Cornell University in 2002. At Cornell, she was also the Order of the Coif, the general editor of the Cornell International Law Journal, and a member of the Phi Beta Kappa. In 2003, she earned her master's degree as cum laude in private international law from the University Paris Pantheon Sorbonne in 2002. She earned her master's in the international law in the American laws and as a cum laude, and also from the University of Sorbonne. She's also done an undergrad as a summa cum laude in political science and French literature from Rutgers University in New Jersey. We're also joined by an international advisor of the society and also a great friend of the society and center, Professor Jennifer Trahan, who's a clinical professor at the NYU Center for Global Affairs and director of the Concentration in International Law and Human Rights. She's a prolific scholar, having published true digests in the case laws of the ad hoc tribunals, as well as scores of law review articles and books, including chapters on International Criminal Court and crimes of aggressions. The book she is currently, what is now published, is the and which the Society and Center hosted, is a legal limit to the Security Council veto power in the face of atrocity crimes. We're quite delighted and quite honored to be in the company of such persons. Of course, I will be doing a big injustice if I don't recognize and appreciate the presence of Professor Popowski, who's tuning in from Tokyo at an ungodly hour. But we will take this as a recognition of our efforts that he's been able to do this. And now with those words, I now invite Professor de Guzman, who's kindly prepared a presentation for us to share the same. Thank you.
Thank you so much, Ankit, for organizing and including me in this really fascinating event. And thank you to Professor Popowski for joining us. And hopefully we'll have a chance to hear some of your thoughts as well as we go forward. So I will share my screen so that I can show you this presentation. Does that work, or do you see presenter view?
We see the presenter view. You'll have to go in and use slideshow, I think. Yes, I think that should work. Yes, okay. Perfect.
So in thinking about the future of international criminal courts and tribunals, I started from the premise of what I've been thinking about in terms of my scholarship lately, because as Ankit said, I like to think about the question of how international criminal law fits within the global legal order. And so where I started with this question was thinking about what my thinking was in February before Russia invaded Ukraine. So the landscape then was, we had an ICC, an International Criminal Court, under fire. There had been an independent expert review that came up with a long list of recommendations and was really quite critical of the International Criminal Court. The court itself had done an internal review and also had many areas where it hoped to improve. But the general view that I saw of the court at that point was one of criticism. States were being very critical of the ICC, were not increasing or decreasing funding and support. African states had been threatening to withdraw not too long before then. We had recently had the US sanctions against the prosecutor and a deputy prosecutor. And so the general atmosphere around the ICC, at least, was one of criticism, I would say. I had been thinking about whether we might see a return toward restorative justice. And this is something that we talked about at the American Society of International Law meeting a couple of months ago. We have had recently in the United States a real resurgence in interest in restorative justice, in part as a result of movements toward prison abolition, racial justice, and a sort of resurgence in interest in economic, social, cultural rights, and using justice mechanisms to promote those rights. And when I say return, it's because in the 80s and early 90s, there had been much more, in my view, much more of a focus on restorative justice, starting with the truth commissions in Latin America that were sort of the primary mechanism for responding to the atrocities committed by the dictatorships in the 1980s. We also had the South African Truth and Reconciliation Commission, which was a really groundbreaking institution that sought to demonstrate the use of reconciliation mechanisms as a way of addressing justice in an era of post-apartheid, post-atrocity. There was also a very interesting development with regard to the ICC in the fall when the situation in Colombia was closed. So over the summer, we had had a new prosecutor elected for the International Criminal Court. And one of the first things that that prosecutor did was to make an agreement with the state of Colombia to close that situation under some circumstance. I'm going to talk a little bit more about that in a minute. What's interesting about that is that the situation had been opened. It was a preliminary examination. So the ICC was considering opening an investigation into the situation in Colombia. It had been open since almost the inception of the court in 2004. Even though a peace agreement had been signed in 2016, it wasn't until October of 2021 that the ICC felt that it was time to close that preliminary examination. So one of the things that's interesting here is that the Colombian peace agreement combines retributive and restorative justice ideas and goals and institutions. And so I have a quote there from the agreement itself, that it strives to be a comprehensive system that places special emphasis on restorative and reparative measures and seeks to achieve justice not only through retributive sanctions. So again, when I was thinking about this in sort of mid-February, this seemed like a significant indicator of when combined with the fact that the ICC had decided to close its preliminary investigation, of maybe a move toward accepting restorative and reparative mechanisms as at least part of the answer, the response to mass atrocities. The mechanisms that were set up by the peace agreement include both a truth commission, the Commission on Truth, Coexistence, and Non-Repetition, as well as a court, the Special Jurisdiction for Peace. And the agreement that the ICC made with Colombia makes a special point of highlighting that this is potentially a model that may be replicated in other situations around the world, and that the ICC and Colombia may mutually benefit from the experience of implementing Colombia's transitional justice mechanism. So to me, this was very interesting as indicators of where we might be going in terms of the future of international courts. Not to say that I was seeing or foretelling any kind of complete turn away from criminal responses, but maybe seeing some more interest in restorative. Okay, then we have this invasion of Ukraine, and almost immediately there is a real, very strong push for criminal accountability. So I thought this was really interesting. Mark Ellis, whom those of us on the panel know well, is at a hotel in Lithuania, and across the street from his hotel is this building with this sign, "Putin, The Hague is waiting for you." The timeline was particularly interesting to me here, in particular, just how rapidly many voices in the global community turned toward criminal accountability. So as you all know, the invasion happened on February 24th, and just a few days later, on February 28th, the prosecutor of the ICC announced his intent to open an investigation into the situation. Just a few days after that, he announced that he had received 39 referrals from 39 states parties. The number is even higher now, completely unprecedented, right? When we've had referrals by states parties, which has only happened a few times, it's been one or maybe a couple, certainly not 39. Then even in the United States, where we had seen, just a year before, the ICC under sanctions, real threats to try and, destroy the court. Now we have Senator Lindsey Graham introducing a Senate resolution supporting an ICC investigation into the situation in Ukraine. Then shortly after that, a number of countries offer additional support to the ICC specifically for the Ukraine investigation. And I will note here that the prosecutor very wisely made it clear that in accepting the funds, he was not accepting them specifically for the Ukraine situation, as some of the states had wanted, but rather for the ICC as a whole. And then the US even launched a program to gather evidence of Russian war crimes in Ukraine. So interesting developments. So this made me sort of think about what is different about these situations, what's happening that caused this really intense shift toward we have to have criminal accountability, we have to have it right away. There are lots of potential answers here, and these were just a few things that came to my mind. I'm very curious what others think. One thought that came to my mind was that there is a real, in much of the global community, many of the voices that are most prevalent, at least in my world, and I'm very curious to hear from those of you who are elsewhere, if you disagree with this or you're seeing other things, that there's a villain hero narrative, right? That Putin is really being cast as a villain. And for those of you who don't know, that's Dr. Evil from Austin Powers, which is probably dating me, but I was, this villain narrative made me think, oh, I wonder if anybody has superimposed his head. And sure enough, there were lots and lots of pictures on the internet of Putin as Dr. Evil. And then, of course, Zelensky as a hero. Aggression is also very often talked about as the supreme international crime, the crime that begets all other crimes. And a good friend to many of us, Ben Ferencz, who is the last surviving prosecutor of the Nuremberg Tribunal, would talk all the time in conferences that many of us went to. Until recently, he's now 102, so he doesn't go as often to conferences, but is still very vocal on this, and indeed has spoken out about Ukraine in this vein, about how important it is to address specifically the crime of aggression, right? So a global criminal law response to the crime of aggression in particular is considered very important by many people working in this field. And so that's another difference. White European victims, a number of people have started to write about the fact that there is a lot of emphasis on putting resources into criminal accountability here, and not as much in other situations where there are also many, many victims, horrific wars and harms taking place that are not in Europe. And of course, as I said, there are other thoughts about the sort of difference that I'd love to hear from others. What else is different here? Well, it's also an international conflict. And so perhaps that aspect of it, where Colombia is an internal conflict, legitimizes global action in a different way, and the focus on criminal accountability in a different way than for non-international armed conflicts, maybe, although, we have seen a lot of emphasis on criminal accountability for non-international armed conflicts, which are most of the armed conflicts in the world. In the past, couple of decades, there's been a lot of emphasis on criminal accountability for those as well. If we think about complementarity, which is the principle upon which the ICC operates, that the ICC should not become involved in situations unless the states most affected are unwilling or unable to do so. Although, as a footnote, they've interpreted this complementarity to also extend to situations where the state's not really acting without really doing an inquiry into whether they're willing and able to do anything in the future. So it's a sort of present moment analysis that they do. So if we think about complementarity, it seems that many Ukrainians want to see global criminal action, whereas many Colombians, although this is very controversial in Colombia, are very interested in national processes, and lots can be said about that if folks are interested in the Q&A. And then maybe the difference between an ongoing conflict where there isn't an immediate prospect of a peace agreement. I tend to be an optimist. Nonetheless, I'm having difficulty seeing a path forward to a peace agreement between Russia and Ukraine in the near future. And this too may make criminal accountability attractive, although for years we've also had these debates about whether there should be a sequencing of peace and justice. So it's interesting that we're not hearing much about the claims that have been made many, many times in the past that active engagement in a criminal accountability process may make it harder for parties to come to the table and achieve peace. But again, this may be because there isn't any real immediate prospect of peace. Lessons for the role of global international criminal law or the future of international criminal courts. Again, I'm speaking very much as throwing out sort of thought balloons, but maybe it's more legitimate. In other words, the involvement of international criminal courts is more legitimate in international conflicts, especially ones that are viewed by much of the global community in this one-sided way. Maybe it's more useful for ongoing conflicts with little prospects of peaceful resolution. And in addition to the maybe there's less concern about peace versus justice, there's also an immediate need for deterrence and incapacitation. So if international criminal law's involvement is believed to contribute to deterring international crimes, and certainly if anyone is captured and taken out of circulation, that would keep at least that person from engaging in international crimes, then that could be a reason why the involvement of the global community in this particular way would be seen as legitimate. And again, maybe it's more legitimate when affected populations favor, or at least don't oppose it. And then lastly, I wonder whether in light of the Colombia and other similar kinds of situations, there might be a conclusion to be drawn about the importance of including other transitional justice mechanisms at some point, right? So even though we're seeing this real push toward criminal accountability in Ukraine at the moment, there may also be a longer term need for other mechanisms, including things like truth commissions. So I'll leave it there. As I said, those were some very preliminary thoughts about what the contrast or the comparison between the situation in Ukraine and in Colombia might mean for the future of international courts.
Thank you. Those are quite illuminating thoughts and perspectives. What we'll do is we'll reserve the discussion for the latter half, and I'll therefore request Professor Melania to share her perspective on this, and how should we rearrange this according to you?
Thank you. It's a pleasure to be here. Thank you for inviting me, and I'm particularly happy to be in the company of my dear colleagues and friends, Professor de Guzman and Professor Trahan. My remarks today will focus on national level prosecutions under the principle of universal jurisdiction. I know we're talking about the future of international courts and tribunals, but I believe that international courts and tribunals cannot accomplish everything, and that these national level prosecutions under universal jurisdiction will continue to complement the work of international courts and tribunals, and will continue to provide another accountability mechanism so that those who commit atrocities, those who commit the commission of atrocities, will face justice, will face accountability. International courts and tribunals obviously are incredibly important in this field of international criminal law, international criminal justice. But as most of you already know, international courts and tribunals cannot prosecute everyone. Most international courts and tribunals have limited mandates, are specifically designed to prosecute those most responsible for the commission of atrocities. Most individuals prosecuted there are prosecuted for so-called leadership crimes. These courts and tribunals are looking at country leaders, generals, country prime ministers, really a handful of individuals. And most of these courts have very limited resources, limited budgets, limited staff. They simply cannot be there to prosecute everyone. And so because of that, I think it's going to be important in the future to also talk about national level prosecutions under the principle of universal jurisdiction as a complementary mechanism, as another way of making sure that those who commit atrocities face justice. And in particular, these are ways in which those who are mid-level or more lower level offenders can face justice. So first, let me briefly talk about the history of universal jurisdiction, and then I'll talk about some more recent uses, some more recent cases under universal jurisdiction. The origins of universal jurisdiction go back to the 16th and the 17th century, when pirates operated throughout mostly the Atlantic Ocean, some other places as well, and pirates were seen as enemies of all mankind, and a customary rule developed that any nation could capture pirates on the high seas and impose the penalty of death by hanging. So the origins of universal jurisdiction go back to piracy, 16th and 17th century. Fast forward to today, and universal jurisdiction exists still over the crime of piracy, but also over atrocity crimes, and also crimes such as slavery, slave trade, and torture. The first modern day case of universal jurisdiction is the prosecution of Adolf Eichmann in the courts of Israel. Adolf Eichmann was a German Nazi leader during World War II. After the war, he eloped to Argentina, where he lived under an assumed identity for several years. And in 1960, Israeli Mossad agents tracked him down in Argentina, kidnapped him, and brought him back to Israel, where he stood trial. The courts of Israel, and this went all the way up to the Supreme Court of Israel, affirmed that the courts of Israel could prosecute Eichmann for atrocities that he had committed during World War II under the principle of universal jurisdiction, and clearly reaffirmed that even though the origins of universal jurisdiction go back to piracy, the nature of the crimes that Eichmann was accused of having committed was so heinous that the principle of universal jurisdiction clearly extended to those crimes as well. Now, before and after the Eichmann case, we have witnessed other instances of national level courts using the principle of universal jurisdiction to prosecute individuals. So, for example, between 1945 and 2010, there were prosecutions for crimes under international law based on the principle of universal jurisdiction in a total of 17 states: Argentina, Australia, Belgium, Canada, Denmark, Finland, France, Germany, Israel, the Netherlands, Norway, Spain, Sweden, Switzerland, the United Kingdom, and the United States. Now, even though the principle of universal jurisdiction became, in this post-World War II era, became accepted and applicable to these heinous crimes, I would like to mention that there are definitely difficulties and challenges associated with universal jurisdiction prosecutions, and that these prosecutions can be controversial. So there are a number of theoretical, practical, and political challenges associated with universal jurisdiction-based prosecutions in national courts. On a theoretical level, there is something perhaps odd about using a court to prosecute someone when that prosecuting form has no link, no nexus to the underlying crime, to the perpetrator, him or herself, to the victims, and when the crime hasn't threatened the national security interest of the prosecuting forum of that country. So on a theoretical level, we are talking about a different kind of prosecution, because all other bases of prosecution in both various national laws as well as international law require a nexus between the prosecuting forum and the crime itself. On a practical level, universal jurisdiction prosecutions can be really challenging. The prosecuting forum is not the place, that country is not the place where the crime occurred, and the prosecuting country has no powers to force the country where the crime occurred to cooperate. And as you can imagine, most of the time, witnesses, victims, and other evidence are going to be located in the place where the crime occurred. And so on a practical level, for prosecutors trying to prosecute someone using the principle of universal jurisdiction, this is going to be really, really tricky. They're going to face a number of practical challenges, and in some instances, those prosecutions might fall apart because of these practical challenges. And last but certainly not least, universal jurisdiction prosecutions can be difficult for diplomatic and political reasons. And the best way to explain this is to use two examples: Belgium and Spain. Belgium had an expansive universal jurisdiction statute about 20 years ago. And then Belgian authorities at the time, as many of you will remember, the United States was involved in the so-called global war on terror and had engaged in some questionable practices. At the time, Belgian prosecutors started talking about bringing cases under universal jurisdiction against then US leaders, individuals such as Dick Cheney and Donald Rumsfeld. Belgium then faced enormous political pressure. The United States threatened that it would basically influence other countries to withdraw the NATO headquarters from Belgium. And as a result of all of this pressure, Belgium actually ended up limiting its universal jurisdiction statute, rewriting it in a way that it no longer is a true universal jurisdiction statute. And the other country, the other example that I would mention here is Spain. In 1998, a Spanish magistrate issued an arrest warrant over General Augusto Pinochet, who had been the former leader of Chile. General Pinochet at the time was seeking medical treatment in the UK. Spain issued an arrest warrant for Pinochet and requested the UK to extradite Pinochet to Spain. This was diplomatically and politically a very difficult case, which also implicated head of state immunity, as Pinochet was a former head of state of Chile. Ultimately, the UK Home Secretary decided not to extradite Pinochet to Spain on medical grounds. Pinochet was already elderly and facing a host of medical issues. But as you can imagine, Spain faced some backlash over its attempted use of its universal jurisdiction statute. And as a result of this, Spain, like Belgium, ended up rewriting and limiting its universal jurisdiction statute. Now, despite these challenges and despite these two examples where we've seen countries really backpedal in terms of using their universal jurisdiction statutes, I would argue that we have perhaps seen a resurgence of the use of universal jurisdiction over the past 10 years, in particular in the wake of the Syrian conflict. And I definitely see an opportunity here regarding the conflict in Ukraine. We might see prosecutions under the principle of universal jurisdiction in order to reach some Russian leaders who ordered the commission of serious international crimes. In the Syrian context, a number of countries have already initiated structural investigations and have already prosecuted, in some countries have convicted Syrian leaders under the principle of universal jurisdiction. And I would also mention that in the context of Syria, these prosecutions are particularly important because there's no other international accountability mechanism available as of today. The ICC does not have, the International Criminal Court does not have jurisdiction over Syrian perpetrators of crimes. And thus far, there has been limited appetite in the international community to create an ad hoc hybrid tribunal for Syria or an ad hoc international tribunal for Syria. And so these national level prosecutions under universal jurisdiction are really the only avenue for accountability today. The most notable cases might be the two recent German convictions of two different Syrians who were accused of having committed international crimes in Syria. And a German court in Koblenz, Germany, has successfully convicted both of these Syrians using the German statute, the German universal jurisdiction statute. Now, a little wrinkle here, I do have to mention this, that although this is a true use of universal jurisdiction by the German courts, these two Syrian individuals were actually located in Germany. And so it was relatively easy for the German authorities to arrest them, to interrogate them, to collect evidence. So although this is a true use of universal jurisdiction, some of the practical challenges associated with universal jurisdiction that I talked about before were not as present in these German cases. In addition to the German cases, a number of other mostly Western European countries have also initiated investigations, prosecutions of Syrians under universal jurisdiction laws, including in France, Sweden, Switzerland, and the Netherlands. In the context of the war ongoing in Ukraine, we might see also in the future some national level prosecutions. One important hurdle in this context is going to be immunity, head of state immunity, where this important principle of international law would apply regarding national level prosecutions. Wouldn't necessarily apply in the international context, wouldn't apply in the ICC, but would apply regarding these national level prosecutions. But I do think that it's important to continue to emphasize the importance of these national level prosecutions under the principle of universal jurisdiction as a complement to prosecutions, investigations and prosecutions that occur in international courts and tribunals. In the future, of course, I'm a big believer and supporter of international courts and tribunals, but I think in the future, we're going to see, the ICC is here to stay, and hopefully states will start supporting the ICC in broader ways that they have in the past. But I'm afraid that there has been a little bit of institutional fatigue and a little bit of a loss of appetite for the creation of new ad hoc tribunals. And so because of that, I do believe the best way to achieve accountability for those who commit atrocities will be to also focus on national level prosecutions under the principle of universal jurisdiction, and that it's going to be important for countries to collaborate and support each other in these types of prosecutions. So we'll stop here. And again, I hope that we have time for discussion towards the end.
Thank you. Thank you, Professor. Let me invite our final speaker for this talk, Professor Trahan.
Great. Thanks so much, Ankit. And it's a great pleasure to once again speak at an event at Jindal Global Law School, and a pleasure to appear with my co-panelists. I'm going to talk about the crime of aggression and its role in international criminal tribunals. So we're, I think, in a very extraordinary time with one permanent member of the UN Security Council having invaded a neighboring state. When you're dealing with a permanent member, there are obvious limitations for international justice because we, of course, confront the veto power of the permanent member of the UN Security Council. And that makes progress in many fronts very difficult. And we've had discussion at this law school about the veto power in past panels. So we've had a clear General Assembly resolution condemning the aggression, agreed by 141 states. Because of our audience today, I will point out that India did not join in voting in favor, and I'm not quite sure why. It is quite a very clear situation. When you have a clear act of aggression, that means political and military leaders who planned, prepared, initiated, or executed the crime have committed the crime of aggression. So it is being committed. Where to prosecute it then becomes more difficult. But I think the events also very much highlight the significance of this crime. Professor de Guzman already referred to it as the supreme international crime. In fact, the quote at in the Nuremberg judgment is, "The crime is the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole." So you see the sentiment behind that. If we don't have the aggression, we don't reach the war crimes. We don't reach all the crimes against humanity and or potential genocide. This is also a situation, very importantly, about enforcing the core norm of the UN Charter, Article 2.4. This is the norm that preserves world order on a day-to-day basis and is very central to the functioning of the international system. So for some who are watching, maybe don't know the history, where is this crime of aggression from? It is by no means a newfangled concept. We see it famously prosecuted before the Nuremberg and Tokyo tribunals. At Nuremberg, count 1 of the indictment was for aggressive war. Count 2 was conspiracy for the same. So they were actually the central focus of the Nuremberg prosecutions. Everyone thinks about Nuremberg as about the Holocaust. It was not. Its key focus was on the crime of aggression. It was not prosecuted at the later tribunals, Yugoslavia, Rwanda, Sierra Leone, Cambodia, Lebanon tribunal, which I think largely were focused on events internal to their situations. Also, somewhat contemporaneously, it was in the drafting process. So those listening probably know that in Article 5.2 of the International Criminal Court's Rome Statute, the court, those who finalized the Rome Statute in 1998 already concluded the crime was one of the 4 Rome Statute crimes that would be before the International Criminal Court, but they created something of a placeholder. The crime needed to be defined and conditions set for the exercise of jurisdiction. This sent us into a lengthy negotiating process that I was privileged to be able to be a participant in. Negotiations were before the PrepCom meetings. Then there was a special working group of crime of aggression. Then we have the negotiations in Kampala, Uganda, where the amendment was adopted. And in 2017, we have the ASP resolution that activated jurisdiction in 2018. But unfortunately, it's quite a narrow jurisdiction. And that is our problem right now with the situation. And it was the US that narrowed the jurisdiction in 2010 and insisted that non-state party nationals be completely carved out. And that is what is now carving out Russian nationals from the crime of aggression jurisdictions. So if we didn't have one sentence in 15 bis paragraph 5 that the US insisted on, the ICC could be prosecuting also the crime of aggression. The UK and France further narrowed jurisdiction related to state parties in 2017. And this is really quite ironic because at Nuremberg, we have Justice Jackson in his opening statement emphasizing that in the future, the Nuremberg principles must be applied against any nation which disregards their requirements, including those which sit here now in judgment. So we are in a particularly ironic time when of the 4 Nuremberg allies that created the tribunal initially, one, the Soviet Union, we have Russia's invasion, and the other 3 have narrowed crime of aggression jurisdiction. So our easiest fix in the current situation would be, of course, Security Council referral of the complete situation. The Security Council has referral powers, and now this includes the crime of aggression, but it is blocked by the veto power. Again, we go back to the veto, which needs to be a situation that needs to be remedied, and we've discussed this in other fora, and it is still a pressing issue. Another easy fix would be get rid of that sentence in paragraph 15 bis paragraph 5. The state parties to the ASP could do an amendment and pull this out, given that the invasion is still ongoing. If they did this now, this would create ICC jurisdiction. I'm not seeing great appetite for this, but I am pointing, this is another very easy fix. There is a review conference or a conference. This issue has to come up again before the states parties, in that the activating resolution called for review 7 years after activation, and that's 2025. So there will be review of the jurisdiction requirements. Given where we are now, and I don't see either of these easy fixes being able to be implemented right now, we are talking about creating a special criminal tribunal for Ukraine to adjudicate the crime of aggression, because the ICC is moving forward on war crimes, potentially crimes against humanity. If there is genocide, it can only move forward on those cases, but not the crime of aggression. So we could have such a criminal tribunal. It could be negotiated between Ukraine and the UN. And this is, for instance, how the Sierra Leone Special Court and the Cambodia Tribunal were created. It would not be recommended by the Security Council, obviously, because we have the veto power, and nor could it be created by the Security Council, like the Yugoslav, Rwanda tribunals and Lebanon tribunal were, because of the veto power. But it could go through the General Assembly. And this is a time period with the Security Council blocked, related to countries such as Ukraine, that you turn to the General Assembly and other bodies to see how much they can do in the face of such paralysis. So the importance of an international tribunal, I think Professor Stereo already referred to the immunities issues that are potentially a problem at national courts. If we're at the international level, we could draw on the precedent of the Charles Taylor case before the Special Court for Sierra Leone, where the court clearly ruled against head of state immunity, even for a sitting head of state. The papers went in when he was still a sitting head of state, and they ruled that there is no immunity before an international tribunal. So this is, I think, definitely the route one would want to take and draw on that precedent. One could imagine the tribunal sitting, for instance, in The Hague. We have the definition of the crime. It is in Article 8 bis. We spent over 10 years refining that definition. That's the definition to be used. It would only be a jurisdiction covering the crime of aggression. One would not need to limit how many it prosecutes, because the definition already has a limitation in it. So you may know the Special Court for Sierra Leone only prosecuted those bearing the greatest responsibility. I don't think you need that caveat, because the crime of aggression only applies to persons in a position effectively to exercise control over or to direct the political or military action of a state. So that's already a fairly constrained subset. So I think there is a clear path for following this. It would be based on Ukraine's request to the General Assembly and then negotiations of a bilateral treaty. Are the votes there? You know, I see people opining, oh, the votes aren't there. Well, honestly, you don't know until you try, until you test the waters and you meet with states, which is the plan in New York. And we will see where this gets. There are other options being proposed out there. I've seen proposals of pooling domestic jurisdictions of a few states. I think that has real selectivity problems. It's not the way to go. Okay, that is kind of what happened at Nuremberg. It was pooling of jurisdictions of occupying powers, but we come a long way from Nuremberg. And, you know, I've seen a lot of UK nationals leading this approach. And honestly, given the Iraq War, it's very ironic to have the UK leading these kinds of discussions, nor should I think the US, for obvious reasons, that we do have some past precedent to overcome. And I'll come back to that in a moment. So pooling domestic jurisdictions, also because of immunity questions, I think is not the way to go. I've seen proposals for an EU negotiated tribunal or OSCE. And, you know, these are potential possibilities, but I don't think this question is a question only for European countries. This is a global question. This is about the global order. This is about respect for the UN Charter. This is an issue that we need this precedent set at the global level. If, for instance, other permanent members of the UN Security Council, such as China, with aspirations on Taiwan, are to be made to take this situation seriously. So I think it needs to come through the General Assembly. I'm often asked on panels, how would you get Russian nationals to The Hague? And this is also potentially an issue for the ICC. And we never quite know the answer to this, but I don't see anyone saying the ICC shouldn't investigate and prosecute war crimes. You have to do the investigation. Even the issuance of a warrant or an indictment is a huge stigma against the perpetrator. You know, I think we should just say, you know, never say never. Slobodan Milosevic, Ratko Mladic, Radovan Karadzic, Charles Taylor probably never thought they would see the inside of a courtroom. So one proceeds. And it is also senior political or military leaders. You know, a number of Russian military leaders have been apparently killed in the conflict to date. It suggests they're not potentially unreachable. So I think we need to simply proceed with international justice. I did mention the issue of hypocrisy, and that does come up on panels I'm on. And it's usually raised, well, what about, you know, the US going into Iraq in 2003? And no one talked about prosecuting the US or UK. I know it's going to sound very technical. The definition of the crime was being negotiated in that time period. It was, you know, it was not finalized. We didn't have a tribunal to conduct these prosecutions. I think these are some of the reasons. There was an attempted domestic court proceeding in the UK, didn't get very far. It was about the use of a UK airfield from which some of the planes took off. And I know that sounds very technical, but those listening will know law doesn't go backwards. If you don't have the definition in place, you can't really talk about prosecutions. But I think, as mentioned, this is just an extremely significant situation to move forward on. You might ask, you know, if we don't prosecute this situation, what are we waiting for? The crime only covers a manifest charter violation. A super clear charter violation isn't going to cover gray area charter violations or ones where there are kind of plausible legal theories, a manifest, such as a flagrant charter violation. And we have had this violation. So I think there's a huge danger in not going forward. May set very dangerous precedent. And we can also say that perhaps it was the weak international response to the invasion of Crimea that has gotten us into the place that we are today. So in conclusion, in terms of the future for international criminal law and tribunals and the crime of aggression, we need to, for the future, amend the Kampala Amendment, go back to Article 15 bis, paragraph 5, and revisit this extremely truncated jurisdiction, which is not befitting the supreme international crime, if we call it that. I actually don't think ranking crimes is a very helpful thing to do, but we need to go back and ensure that its jurisdiction isn't so much more limited than the jurisdiction for genocide, war crimes, crimes against humanity. There's just no reason for this huge difference. And I think in this situation, it is imperative to prosecute the crime in a legitimate forum. The most legitimate forum would be a broadly endorsed response going through the General Assembly. And I think this is the current challenge to try to put this in place. So I'll end here. Thank you.
Thank you to all our speakers for sharing their perspectives. Professor Pawlowski's been dropping in and out. I do see him in the meeting. Professor, would you like to?
Yes, let me quickly kind of support all suggested avenues here. And exactly because of the difficulties and the limitation in either way, whether we go to the International Criminal Court, whether we go to domestic tribunals applying universal jurisdiction, or whether we establish a special court for the crime of aggression within the General Assembly, and all three avenues have been already deliberated, and I will suggest these are not alternatives, that there are no substitutes. All efforts should be made in all directions, exactly because of the limitation of each one. I'm very curious about the comparison Colombia-Ukraine here, which are quite different on one sense, because Colombia was internal armed conflict, where Russia-Ukraine is definitely an international armed conflict. In other words, I assume some comparison can be made in case where some internal tensions emerge in Russia in the future, and whether the anti-Putin and pro-Putin communities may get into kind of a civil war and fight, and then need of some reconciliation afterwards. In other words, but academically, let's put it this way, academically, I enjoy very much the presentation, to the point that many of the issues raised actually do apply both to accountability mechanism within internal context and international context. So for that matter, a lot of questions there about what other options, apart from judicial options, apart from criminal tribunals, we can think of as to deliver justice and reconciliation long term. So how restorative justice can be applied in international armed conflict is very much a gray area. We have to do more research and deliberation on that. Thank you, all three of you. I really, although my line was not stable, I really appreciate your time and your excellent contribution to the Jindal Society. Let's move to some questions, Ankit, and comments from participants.
Yeah, I just scribbled a few questions, and I'll start with the one on universal jurisdiction, and perhaps based on one of the readings which I could peruse, suggests that on the 19th of May, a 21-year-old Russian tank commander, Vadim Shishmarin, pled guilty to shooting of a unarmed 62-year-old civilian who was riding his bike in eastern Ukraine in the Sumy region. And the first war crime trial relating to the ongoing war crisis was launched in the courts of Kiev, which sentenced the Russian soldier to life imprisonment. So perhaps this universal jurisdiction could start and also perhaps end in Ukraine? Or do you feel that other states will be willing to take up jurisdiction given how crucial Russia is in terms of supplying resources to them? And we've seen how far India has went, and also the other Europeans have.
Yeah, I'll start, and then Meg and Jennifer can also weigh in. But the example that you cite, the Ukrainian prosecution of this Russian soldier, is obviously not an example of universal jurisdiction. That is an example of clear territorial jurisdiction, because these crimes were committed on the territory of Ukraine and affected Ukraine. If you put that type of a prosecution in the courts of another country, though, then that other country would have to use presumably universal jurisdiction to prosecute the same soldier. So just a couple of quick thoughts on this. So first, if you approach this from this angle of accountability, right, you're going to say, oh, this is great. Now we have prosecutions in Ukraine. But if you approach this from the perspective of defense rights, due process rights, you might be a little bit skeptical, because lots of questions have been asked about the ability of a country that is part of an ongoing conflict to actually conduct fair and neutral and unbalanced proceedings. And in this case in particular, you have a very young soldier who in a matter of sort of 2 or 3 days was convicted to life imprisonment. And if you wanted to draw parallels to other cases, the one that comes to mind, at least for me, is the case of Adamovich in the ICTY, who was a soldier in the Bosnian Serb army, was one of the shooters at the Srebrenica massacre. He was convicted by the ICTY, but sentenced to only 5 years of imprisonment because of basically questions about duress. And then the court also took into account his young age and all of that. So you could compare and contrast that case to this Russian soldier, and you have to ask questions about the ability of courts of not just Ukraine, but any nation to have fair and balanced proceedings when they're basically being attacked by this other country and they're prosecuting someone from that other country. So that's just one point about that case. And then on universal jurisdiction, you also bring up an important point, and that was part of my presentation, that oftentimes universal jurisdiction cases encounter political challenges. And so you're absolutely right to point out that some countries might not be willing to use their courts and extend this principle of universal jurisdiction, even if they have it on the books, against Russians, because they might depend too much on Russia in terms of their economy. Politically, Russia is a great power. And so obviously there's this political and diplomatic dimension to these cases. But I suspect, I don't want to be, too optimistic about this, but I do think that at some point in the future, we might see the courts of some, let's be honest, Western European nations being willing to use the principle of universal jurisdiction and prosecute some of these cases.
I'll just add, if you don't mind, I'll just add something there, which is that I think it's been very clear that the Ukrainian authorities have significant capacity and will to engage in prosecutions, and they want to be leading efforts to investigate these crimes. So from what I've been able to tell, it will be very important for other states that might want to support Ukraine to do just that, to make sure that they are supporting Ukrainian efforts and not trying to take the focus away from Ukrainian efforts to achieve the kind of justice that Ukraine is looking for. So I definitely, as a former defense attorney myself, I am very much attuned to the issues that Milena raises about fairness of proceeding, and I won't comment on that particular case. And by the way, this reminds me that I'm supposed to always say that I'm speaking in my individual capacity, not as a judge of the International Residual Mechanism for Criminal Tribunals, Residual Mechanism for International Criminal Tribunals. And having just basically recently become a judge, I always forget to say that. I do share those concerns. At the same time, I do think it's very possible for a state to have a system that is strong enough, even in the midst of armed conflict, to be fair in cases like the case that just happened. So without commenting on that particular case, and that does sound like an extreme sentence for that particular case, I don't think that it's impossible. And I just want to emphasize, because I think there are a lot of different organizations that are now trying to become involved in investigations and potential prosecutions with regard to Ukraine. And I just think that we should be careful to make sure that those efforts are aligned with Ukrainian efforts and trying to support Ukrainian efforts.
I could add maybe a little bit on just to where Meg ended, that I think there is now a joint investigative team being formed by various countries and the International Criminal Court. And I think various European countries already have opened war crimes investigations into crimes in Ukraine. The difficulty of all this is one of coordination. So, you know, we already have a human rights mechanism investigating. Then we have the International Criminal Court, we have Ukraine, we have a number of European states, and coordinating this all. And then there are, you know, huge numbers of NGOs getting involved in documenting. We have, you know, citizens documenting because they can use their iPhones, and somehow coordinating all of this. There's huge interest in bringing these war crimes and aggression and or other cases. And it will be a challenge to coordinate all of this.
I agree with all three of you on this, and I think every beginning is kind of a difficult, also because the war goes on. So somehow the dilemma, peace and justice is here as well. Obviously, we saw in previous examples how sometimes we need extra time to get justice done, not in the middle of the war. And it was also the case with Yugoslavia and Rwanda. So for that matter, I fully agree, by the way, that the international assistance to Ukraine is crucial here, exactly as not to have heavy bias on the side of the prosecutor against the defense. And that should happen. That's what United Nations and other assistance, judicial assistance to Ukraine should offer here, as not to have harsh sentences on young soldiers, such as the first case. On Erdemovic in Yugoslavia, it was not only because he was young and under duress, but also he did plead guilty. He did cooperate with the judges. Actually, he delivered crucial evidence to indict later Radovan Karadzic. So somehow that message was very important, that the tribunal should encourage guilty pleas and also helping the investigation with evidence. And if that works well, as it did work in the case of Erdemovic, Yugoslavia, that's also another opportunity here.
Well, I just wanted to stay with this point of complementarity as was being spoken about earlier. And the chief prosecutor just a few days ago was speaking to the Nuremberg Academy, Karim Khan, and he spoke that these foreign ministries and governments have been involved in a unique way. And he suggested the example of the Dutch forensic team being involved and an entire contingent going to Ukraine and setting up a sort of an ad hoc, almost a tribunal there. So I think these are unique ways in how these governments can also get involved, provide logistical support and not just support in terms of hardcore legal assistance to such endeavors. I'd be curious to know if there are more such examples of how states are contributing towards this in a practical and meaningful way.
How states are, just to clarify your question, how states are contributing to the Ukraine investigation?
Yes, in the Ukrainian investigation or these international investigations which are taking place. And let me stop there and then we'll come to tribunals.
Yeah, I'll just say one quick thing. I know that, this was part of Professor de Guzman's slides. We saw in the context of Ukraine, we saw the ICC prosecutor basically announce almost immediately, we're now, resuming this investigation. And we saw a number of states first, willing to refer the situation to the ICC, but then also we saw a number of states willing to support the ICC by lending teams of investigators and prosecutors, basically lending human resources to the court. So I think that's an important example of state support for the ICC. I think the ICC needs much more state support, not just for Ukraine, but for all of its other cases, needs more money. but I think this is at least a positive example of state support for the court in the context of the Ukraine war.
And maybe I'll just add on to that. Although, this seemed all very good, and this was brought out in Professor de Guzman's presentation, this great outpouring of support for prosecutions in Ukraine, you have to wonder what victims in other situations might have felt about all of this. And it's really, and the ICC prosecutor, having basically called for, funding for Ukraine, had to kind of backpedal and say, okay, no, this goes generally to the court, because you really don't want to be in a situation where states say, okay, I want to give money or, personnel to X situation. Because then we get into, I'll give to Burundi and Palestine, but not Afghanistan. Like we never want to get there. Basically, the ICC just needs a more fulsome general budget. And what you want to do is translate some of this very selective support and say, no, the ICC as a whole needs it, because we don't want states kind of potentially controlling the ICC's docket, or wanting, specific positions that, of influence over certain investigations. We just don't want to kind of go down that rabbit hole of states having leverage to direct where the ICC is putting resources. So in the long run, we just need money to the general budget.
Professor Popowski, would you like to?
I want to ask Jennifer about her expectations for a special tribunal on the crime of aggression. Yes, we know that several barristers, the former Prime Minister Gordon Brown, Philip Sands, and others in London were initiating with the government of Ukraine, with the permanent representative of Ukraine, United Nations, the idea of a kind of a Nuremberg type tribunal for the crime of aggression. So do you think there is enough political will, enough desire to see that going?
Well, I give Philippe Sands and others credit for putting the issue on the table. Simultaneously, I think they proposed a very bad model. So they started us off on the wrong foot of a couple European countries and Ukraine pooling domestic jurisdictions a la Nuremberg. So I think we now need to regroup and try to do this appropriately and go through to the General Assembly. This isn't a question for a few countries. This is a question for the international community. And you don't know until you have tried it. The challenge is now to meet with the Ukrainians, get them on board with the proposal for basically an international tribunal the size of the Sierra Leone Special Court. So people have kind of sometimes called it hybrid. I think I've written about it as hybrid, but you could also think of it as international, because I actually think you want international judges. And I think maybe I didn't say that before. And it is for the reasons we talked about. Would Ukrainian judges be neutral to aggression in this situation, impartial? I don't think so. So you really want to have the most, the best process possible. I know, ironically, for your worst crimes and your worst perpetrators,
exactly.
You want the best process possible.
You don't want to repeat Nuremberg, where American and Soviet prosecutors were prosecuting Germans.
Exactly.
So we need the United Nations. We need the world.
We need the United Nations. It has to be an international.
Judges from everywhere, judges from Africa and Latin America to be those prosecutors. And the prosecutor should come from all over. Exactly. I think for that one, but I am a little bit more optimistic here, because if the rest of the crimes, the war crimes, the crimes against humanity require really not to speak about genocide, where you need a huge amount of evidence to prove genocide. I think for the crime of aggression, it's pretty much clear. Well, Russia violated everything which exists in international law. I don't think any prosecutor will have much of a problem to try crime of aggression in such a flagrant, across the boundary, military, territorial case of aggression. So here, really, we really need to have the global will behind this tribunal. And as you say, we don't need Ukrainians. We need the kind of third party, sorry, not third world, but third party prosecutors and judges for that tribunal. So I'm very happy to continue deliberating and actually even possibly influencing that decision.
Excellent.
I also would just add that I think in terms of the absence of immunity, I think it's very important to have quite a strong presence of internationals in the court, because I think that even the decision of the Special Court for Sierra Leone to kind of proclaim itself to be an international court that didn't have to recognize immunities of heads of state was controversial. And in order to make this court as legitimate as possible in prosecuting a head of state, I think it's really important that there be widespread international participation.
I think Meg is absolutely right on that. It was a little funny. The Charles Taylor decision says there is no head of state immunity because we're an international tribunal. And in fact, they were a hybrid. They weren't a full international. So it's a little bit odd in that decision. And if we went the full, international judges and not a hybrid tribunal, the more international, the more legitimacy in the eyes of the world we will have. And I think the more secure we will be on the immunities questions. Absolutely.
Now, if I could just jump in on, sorry to sort of co-opt this conversation, but this is so exciting. And I know Professor de Guzman has to go, but what do you think about the possibility of, you're going to have the ICC, maybe this hybrid tribunal for aggression that's going to be able to circumvent immunity issues. But what about having a specialized war crimes chamber within the Ukrainian system that would then prosecute the sort of mid-level and lower level offenders to sort of have this full arc of accountability? That's what we saw, for example, in Bosnia. You've got the ICTY, then you have the Bosnian war crimes chamber. I do think that there is, that it is important to also talk about that.
You're absolutely right, Millen. Yeah, exactly. And I think Dr. Popowski referred to, all of the above is usually the answer. We all try all of the above. And in Bosnia, the state court is a particularly good model of a hybrid tribunal because it was hybrid and then, phased out.
We have seen how domestic tribunals can take over after some time once they are capacitated. You mentioned former Yugoslavia. We can see that in other examples where I hope also that I always consider the ICC to be like a temporary mechanism until all states in the world have the capacity to do it domestically. We don't need the ICC if every country in the world can do the same job within their legal system. So that's the message here. International tribunals are temporary. They are very helpful to remove the bias and to capacitate. But after that, the domestic courts should follow, and it happened with ICTY as well.
I'm curious what, Milena, when you raise the possibility of a specialist chambers, what would be the benefit? What would you see as the main reason to do that, as opposed to having the mid-level and lower level just tried in the regular Ukrainian courts? Because in some of those other situations, there's been an issue of expertise and capacity that may not be as relevant in the Ukraine situation, in part because they've been thinking about these issues and working on domestic legislation to incorporate the relevant crimes and so forth for a really long time. So I'm wondering what the benefit would be of a specialist chamber.
Yeah, I actually, so through the Public International and Policy Group, over the past year, we actually have worked with the Ukrainian government on, helping basically with some of this draft legislation, including, for example, this draft law on transitional justice. So I know that there's capacity, but I also know that they need help. So, I do think that there would be a benefit in having a specialized chamber with international support, because I do think that they need help based on everything I've seen. So, there's some capacity, but I think there is a lot of room for international expertise to make sure that these proceedings are conducted in a fair and neutral way, to make sure that there are no concerns about, bias or what have you. So that's just based on my experience, what I've seen over the past year.
I think we've had a substantial discussion, and perhaps we can close now, if that shall be permissible to all our speakers. Professor Trahan. Okay, let me just offer a...
Did you want us to give closing remarks? I'm sorry.
Please. You're familiar with my protocol now, so you might as well start.
Okay. So
please.
I will close by saying it is always very hard to do accountability when you're dealing with a permanent member of the UN Security Council. And this is, Syria also was a situation where a permanent member played a really unfortunate role in direct military intervention and complicity in the crimes, and then was able to block accountability, which is why one had to try to do universal jurisdiction, because all the direct paths for accountability were blocked. And we reached this in too many situations. We have it regarding genocide against the Uyghurs, and because of China's position in the Security Council, we won't have a tribunal, we won't have a referral. All your ordinary paths to accountability are blocked. And I think universal jurisdiction in that situation becomes harder. We're having a real impasse because of the veto power, and it's really limiting the possibilities. So then we have to go around to, what are all the alternatives that can be pursued? We wouldn't have to create a whole ad hoc aggression tribunal if one sentence in the Rome Statute, could be amended, or we could have a quick referral. So international justice is challenging, but you have to push, and you have to, you do your best. And I go back to all of the above, try all of the routes, the way to try to prosecute, and it is really challenging. But I think it goes back to the problem that Professor Popovsky, I know, is working on in other fora, the problem of the veto power blocking so much of the council's ability to be productive.
Professor de Guzman, please.
Yeah, so this has been a really fascinating conversation. I guess my final words would be to those of you who are working on these issues with regard to Ukraine and elsewhere, not to lose sight of the other aspects of justice apart from criminal justice. I think there's a lot of energy and movement toward criminal justice. And, as someone who has spent my career working to promote criminal accountability for atrocity crimes and is now a judge on a court that does that, I am certainly, in favor of working toward that end. But I also think that we have to be careful not to lose sight of some of the other needs of the populations that are suffering from massive human rights abuses, and needs for other kinds of transitional justice mechanisms, needs for other kinds of support, including if you talk to Ukrainian leaders now about criminal justice, they're very happy to talk about it. But at the end of the day, when you say, what do you need? What kind of support do you most need now? The answer I hear over and over is we need weapons, right? We need help ending this conflict. So let's all also stay focused on trying to end conflict and prevent, massive human rights violations through whatever means we can, in addition to accountability. So those would be my parting thoughts.
Professor Stereo, please.
Thank you. So first of all, let me reiterate that it was really a pleasure to participate. And I like how Professor Popovsky called it a brainstorming session. It really was. And I would just reiterate my comments about the need for sort of a full arc of justice. If we're talking about accountability, the ICC has this investigation open. The ICC can do some things, but it cannot do it all. It cannot bring to justice all of those or most of those who commit crimes or who have committed crimes in Ukraine. We might have an ad hoc tribunal for aggression. Great, right? But that tribunal will also be limited in what it can do. And so I do think that we also need to continue to talk about other national level mechanisms for accountability, including prosecutions in Ukraine, but then also possibly including prosecutions in the courts of other countries based on the principle of universal jurisdiction. Thank you.
Professor Popowski, please.
I just want to thank all three speakers. It was really amazing to deliberate what can be done in a specific situation, and I'm still keeping optimistic. Again, crimes never end, but also the law enforcement never ends and improves over time. So although we always say that this should never happen again, nunca más, never again, crimes do happen. We have somehow to admit that, but also to improve our responses to those crimes. And I think we do generally, exactly through the discussion today. I learned a lot from all three speakers. And this is the beauty of the discussion, is exactly to construct suggestions and to influence decision making and to make those happen. Thank you all once again. Happy to see you anytime. Welcome to India one day. Visit us in Jindal whenever your time permits. Hope to see you there one day.
That would be lovely. Thank you so much.
Thank you.
Yes. It would.
Thank you. Thank you, everyone. Thank you so much for your time. We shall remain connected and hopefully do something with the upcoming event of the American Society. Thank you. Thank you, everyone.
Thank you, Ankit. Take care, everyone.